Hi, good afternoon. Good afternoon and welcome everyone. Welcome to this webinar, Protecting the Best Interests of Non-Citizen Youth in CHIPS Proceedings, Key Updates for Minnesota Child Service Workers. I'm Stacy Geringer, the Associate Director of Outreach at the Center for Advanced Studies in Child Welfare, also known as CASCW. We're a research and training center located in the School of Social Work at the University of Minnesota Twin Cities. And we're thrilled that you could join us today. We're really excited to get started. Thanks for being here. A few housekeeping items. Due to the volume of attendees, we had over 500 registrants. We're going to be closing the chat. We encourage you to use the Q&A during this webinar. This webinar is not intended to provide legal advice. Remember to connect with attorneys directly about individual consultation. Questions should be general in nature and non-identifying to protect privacy. Even if we don't answer your question live today, all the Q&A questions will be saved and answered by the presenters, and we'll email that to the attendees after the event. The presentation will be recorded. The Q&A portion will not be recorded. PowerPoint slides will be emailed to all registrants, and we'll also put them in the chat. There'll be a brief survey at the end of this webinar. Before we start, I'm going to take a moment to acknowledge that the university and the land on which it is located is the unceded, traditional, ancestral, and contemporary land of the Dakota people, who are the first people of Minnesota Makoche. By offering this land acknowledgement, we affirm tribal sovereignty and work to hold the university, ourselves, our learners, and our partners accountable to Indigenous peoples and nations. Additionally, we make a labor acknowledgement to affirm that the culture, economic vibrancy, and growth of the United States as we know it today was created through the enslaved labor and sacrifices of Black Americans and their descendants. Each of these acknowledgements are critical elements of our work within child welfare, knowing that the horrors of human trafficking and violence and trauma are part of our history and ongoing, and the area of practice in which we choose to be allies and helpers. May history teach us as it demands changes in our practice. I'd now like to welcome our speakers, Allison Griffith and Kim Boucher. Allison is a supervising attorney at Mid-Minnesota Legal Aid's Immigration Law Project. Kim is a supervising attorney with the Advocates for Human Rights Refugee and Immigrant Program. We're really lucky to have them to help provide some guidance on a variety of issues related to screening and the referral process for legal rep at the onset of CHIPS proceedings, and just give us some more resources for doing the work. Welcome, Allison and Kim.
Thank you so much. We're thrilled to connect with this group who is providing such essential services to youth. I have been an immigration lawyer since 2014 and have focused on representing youth for the entire time that I've been practicing immigration law, and have had the chance to connect with child welfare caseworkers across the state. And just want to emphasize that every caseworker I've worked with really has had the desire and the goal to assist youth and to accomplish their best interests. And so we're here today as allies with you to ensure that youth are getting the services that they need, and that we are collectively able to protect the best interests of youth. Kim, do you want to share any additional introduction?
Yeah, with the Advocates for Human Rights, we have a team of attorneys and pro bono attorneys that represent unaccompanied minors as well. I've been practicing since 2020, and yeah, happy to be here.
Great. So just to give you a little roadmap of what to expect today, we're going to do some term defining. Who are non-citizen youth? What are the various ways that statuses that youth could be in? How youth can pursue pathways to permanent legal status, flagging some particular concerns around international adoption and immigration status, address crucial policy changes in immigration court and with USCIS that create greater urgency in referring to immigration counsel and to working collaboratively with immigration professionals, and also provide you referrals and know your rights resources and safety planning resources. and have time to address your questions. So we want to just reiterate, we're not giving legal advice. You really, folks should connect their clients and youth that they're serving with immigration lawyers regarding particular questions. The information in this presentation reflects the law as it is today. We encourage attendees to continue to seek updated information as policies change by continuing to seek training on immigration issues. Our goals today are to leave caseworkers with a few crucial takeaways. We are not seeking to make you immigration experts. We know that you have many things on your plate. The crucial takeaways are we want caseworkers to have a clear understanding of the increased and always crucial importance of timely and confidential verification of children's immigration status and timely and confidential referrals to qualified and knowledgeable immigration counsel that can help youth achieve more permanent status. We also want to leave you with resources for safety and emergency planning that you can use with non-citizen youth and their guardians. Again, you do not need to be an immigration expert, but your role in providing these timely referrals to immigration counsel and doing safety planning cannot be overstated. So we'll start by talking a bit about what might be the status of a youth who's a non-citizen. So there's various situations that youth can be in as non-citizen youth, and citizenship status, of course, comes with all the rights that individuals who are citizens of the United States enjoy. Individuals who are citizens cannot be deported, can vote, can travel freely, and this is the goal that we would have, is that youth who are leaving CHIPS proceedings are in the best position to attain citizenship status. Permanent residents have the next level of rights. Permanent residents can be deported if certain things happen in their lives. They have more restricted travel rights, and they cannot vote, so they do have lesser rights. However, permanent residents are much more protected than individuals who have more temporary status. For example, immigrant visa holders, such as holders of common types of visas, are U visas and T visas, and Kim is going to tell you a little bit more about how youth might become eligible for those forms of non-immigrant visas. Immigrant visa holders and non-immigrant visa holders may have work authorization, temporary permission to be in the United States, and often pathways to permanent residence, but we want to emphasize they may need to wait, often years, to become eligible for permanent residence. So those who may be eligible for these forms of relief, it's particularly important that they receive speedy referrals to immigration counsel so they can get on these pathways as quickly as possible. There are also individuals who may have temporary protected status, deferred action, including deferred action for childhood arrivals, or DACA, and other forms of temporary status. Many of these forms are created by the executive and exist based on the discretion of the executive and branch, and some of them are going away at this time. Those who have temporary status would have temporary permission to be in the United States and work authorization, but many of these pathways do not carry any way to become a permanent resident. And so individuals with these temporary forms of status need to be referred to assess if they have pathways to a more permanent status in the United States. Children with non-immigrant visas, like student visas or visitor visas, may or may not have work authorization and have temporary permission to be in the United States, with the understanding that they would ultimately return to their country of origin. However, youth with this type of status may have pathways to permanent residence as well. For example, we see kids who are holders of student visas and had every intention to return to their home country, but something changed. For example, they came out as a gay youth in the United States and are living as themselves, and they know that if they returned to their home country, they couldn't live safely there. And that youth may have a pathway to permanent status through asylum and any youth with these temporary statuses, such as visitor visas and student visas, should also be referred to immigration legal service providers to assess if they also have pathways to permanent status in the United States. Undocumented children who have never had contact with immigration authorities and do not have any type of permission to reside in the United States or work authorization, so no form of identification, federal identification documents, are particularly vulnerable at this time of increased enforcement and should be referred to immigration counsel so that they can make informed decisions about the pathways to status that may be available to them and how to best protect themselves. And I want to emphasize that undocumented youth, although they don't have immigration status and have fewer rights under immigration law, do have many other rights that caseworkers can assist them in protecting. For example, they have rights to a free public education and rights under state law, rights to privacy. So these youth have all the rights that other youth do while they have fewer rights under immigration law. And then there are also youth who are in removal proceedings, and youth can be in removal proceedings either on their own, depending on how they entered the country, or with their parents. And these youth particularly are in need of quick referrals to immigration counsel. The emphasis is all youth should be referred as quickly as possible to immigration counsel, and we'll talk about how to do that. But if kids are in removal proceedings, they are required to appear at hearings before immigration judges, and if they don't appear at the hearings, they will almost certainly be ordered removed in absentia and be vulnerable to removal at any time. The requirement that they appear does not end just because they're placed in CHIPS proceedings. They're still expected to show up at hearings in immigration court, and if they don't show up and there's no explanation as to why they're not there, judges will order them removed, typically, rather than continuing proceedings to find out why they couldn't appear. And we'll talk a little bit later about situations that are making removal proceedings move more quickly at this time and making folks in removal proceedings more vulnerable to removal, making it even more crucial that they connect with experienced counsel. Last point on this page is that youth are not going to self-identify. They're typically not going to tell you, hey, I need access to immigration counsel. I am in removal proceedings. Youth often are not familiar with legal proceedings and depend on adults in their lives to make them safe and to help them recognize eligibility for legal services and obtain referrals to organizations that can assist them. And the adults in their life, if they're in CHIPS proceedings or delinquency proceedings, are you. You are the best positioned to make these referrals and to do the things that parents would otherwise do for youth. So very important as you're screening youth to establish a procedure that allows kids to know the information you're asking them about whether they have a US birth certificate and social security number will be treated as confidential, is only being obtained to refer them to immigration counsel, that you will not be sharing any information with ICE or immigration authorities, and that ultimately you are there to serve their best interests so that they know and feel comfortable sharing this information with you that is so sensitive, particularly if they've been removed from their home and may have some concerns about whom they can trust within the system. So just wanting to emphasize a few additional terms. So removal proceedings, that means that kids are in, there are a few different types of removal proceedings, but typically for youth, they would be in a type of removal proceeding where they would be required to appear before an immigration court and report on any benefits or defenses from deportation that they are pursuing, and ask for time to pursue those forms of protection from deportation. We do have an immigration court here in Minnesota at Fort Snelling, right in the Twin Cities metro area by the airport. And I want to emphasize unaccompanied alien children have special rights under immigration law that we'll discuss more in a moment. For someone to be considered an unaccompanied alien child, they need to be under 18 and not have a parent or legal guardian available to care for them in the United States. There are certain rights that accrue to youth who entered the United States as an unaccompanied alien child, even if they're no longer an unaccompanied alien child under immigration law. And I just emphasize that that has a different definition than unaccompanied child under Minnesota law, which you might be familiar with for helping kids access school benefits and things like that. And just emphasize that all youth need a referral who do not have both proof of citizenship and a correct Social Security card. And a few additional things to emphasize: the best interest standards that governs all cases in CHIPS, all CHIPS cases, applies to undocumented and non-citizen youth in the same way. There's no change in the standard that governs these cases. I just bring this up because we occasionally see judges or other stakeholders within the system have confusion about this, but the same factors that should be considered for all youth in achieving permanency and best interest should be considered for these kids. So there's a strong consideration of the child's preference regarding their permanency plan when they're old enough to express that preference. And all factors relevant to the needs of the child should be considered, including medical, educational, developmental, religious, cultural, relationships with siblings and other caretakers, etc. And there's an additional statutory obligation to non-citizen youth that requires timely referrals and safety planning. Minnesota Statute 260C.452 subdivision 4C specifically requires that responsible social services agencies assist the youth in obtaining permanent resident cards. Many folks have shared that they have some questions or concerns about how to achieve this goal. It's clear that caseworkers want to achieve this goal, and we're here to provide resources for how to do that. So what is a timely referral? We want to emphasize a timely referral is as soon as the judge has made a prima facie determination that a CHIPS matter exists. So at the outset of proceedings is when referral should take place. If folks wait until the end of the CHIPS proceeding, it's likely that kids may already have a removal order, may be vulnerable to being picked up by ICE at any time, may have aged out of eligibility for immigration status, and may face many other barriers to permanent residence that wouldn't exist if the referral takes place early enough in the proceedings. And I'll turn it over to Kim to share about pathways to status.
Yeah, thank you. So there are a ton of reasons why we're seeing kids leave their homes and home countries, anything from discrimination and corruption and violence in their home country to extreme poverty, lack of opportunity, lack of education, lack of a viable caregiver in home country to be able to rely on. Next slide. And once they get to the United States, kids are bombarded with many individuals and many bodies to sort of suss out on their own, essentially, unless they find immigration counsel. So when they enter, they are apprehended by CBP, that is folks at the border, Custom and Border Patrol. If they get through the border and are identified within the United States, not within 100 miles of any border, they might interact with ICE, that is the folks dedicated to internal apprehensions, that is the folks that we are seeing on our streets right now. When they are applying for benefits, many of the benefits that youth are eligible to apply for is yet another agency, USCIS, that is in charge of asylum applications for youth, special immigrant juvenile status, which is the most relevant for you all if you're dealing with any of these CHIPS proceedings. And once they are within our custody and care, being the United States' custody and care, they are placed within the Office of Refugee Resettlement. That is the agency that is set to take care of the youth as they enter, if they are unaccompanied, and then later has to assess whether or not there is a viable guardian or parent that they can then be transferred to or released to once the appropriate security checks have been cleared. All of the youth are also dealing with EOIR, that is the immigration court. So once a child is entering, they are pretty immediately placed into immigration court proceedings. They're given a document that is supposed to tell them when and where to show up for immigration court. And at that immigration court, a judge asks them, so why are you able to stay in the United States if that is what the child wants to do? Aside from that court proceeding, if someone is applying for special immigrant juvenile status, or if someone is in CHIPS proceedings, they're also interacting with state courts. So it's a lot of individuals, a lot of people that youth get introduced to right away as they are entering the country. Go ahead. And so it is very confusing for youth to be able to sort of identify who can I trust, what forms of relief are there for me. So if you go to the next slide, it shows us what an immigration court looks like when you are first entering it in. You're supposed to show up ideally with a parent or guardian. Some parents right now are not entering these immigration courts because of fear of getting picked up by ICE. So kids under 18 are sometimes showing up to immigration court alone and being asked by the judge, why are you here all by yourself? Yet another reason why we need kids to be able to present themselves with counsel. If we go to the next slide, one of the forms of relief that you might present at these immigration courts is special immigrant juvenile status. This is specific to any youth that is under 21, which is fantastic. The federal age for a child is under 21, not under 18, that have been abused, abandoned, or neglected by one or both parents. Doesn't have to be both, can only be one. And that process, if you go to the next slide, is sort of a three-part process for getting to that green card, that more permanent protection for the youth. The first part is going to be a state court, essentially is finding that the child has been abused, abandoned, or neglected. We'll go into what specifically those orders have to entail. Then an immigration attorney takes that order from the state court and applies for that special immigrant juvenile status classification. At the moment, that classification isn't being seen as actual viable form of relief that is going to keep you here in the US. The government and the courts wants to see that green card. That right now is only being it's only moving forward within like 3 to 4 years because there is a backlog of visas available to all of these youth. We only get about 10,000 a year for all of the youth applying, and there's many, many more youth that need to be able to apply for these green cards. So a lot of kids are being stuck in that middle portion where an I-360 SIJS application is being filed, probably approved, but then are not able to move forward to that legal permanent residence status just yet. And if we go to the next slide, I just want to briefly cover.
Kim, can I just?
Oh, go ahead, Allison.
Yeah, just two things I want to highlight. One is that youth can get these findings, and stakeholders in the CHIPS proceeding should work together collaboratively. And sometimes it's also possible in juvenile delinquency proceedings where there's a change in the child's custody. To get the findings necessary in that CHIPS proceeding. So oftentimes through the guardian ad litem reports or the findings that are made in the course of making a permanency decision, many of the facts needed to make the SIJS findings that allow kids to pursue SIJS can already be made based on the record. And the immigration attorney can work with the county attorney, with the caseworker, with the juvenile defense attorney to get those additional facts into the record that are necessary to make the findings. I've had judges ask me, oh, is this child going to pursue an at-risk juvenile guardianship? to get the findings, and that's not necessary. The findings can be made in the CHIPS proceeding, and as Kim is talking about, there is such a long wait list that it's really important that kids apply for SIJS and get in the wait list as soon as they can. And some attorneys have asked, well, should we even be pursuing these findings for kids if SIJS isn't something that is preventing removal? Immigration attorneys can work with kids to assess, are they eligible for other relief? What can we do to advocate for them in removal proceedings to prevent their removal? So we definitely encourage you to still work with kids to get these findings if they've consulted with an immigration attorney and they've made the choice that they want to pursue SIJS after that informed discussion with an experienced immigration attorney. Back to you, Kim.
Thank you, Allison. Yeah. So as Allison was saying, these juvenile courts can be proceedings in the CHIPS posture. It could be divorce proceedings, custody proceedings. If a child is getting in criminal trouble, it could be in those juvenile delinquency proceedings. The court just has to find three things: that reunification with one or both parents is not possible because of abuse, abandonment, or neglect, that it is in the child's best interest to not be returned to their home country. There's no caregiver in home country that is eligible or available to care for them. It's the best interest for them to stay here with their guardian, and that they are declared dependent on a juvenile court or placed under the custody and care of an agency. So folks that are in foster care, if they are placed under the guardianship of a specific agency or department. We have folks in North Dakota that are under the care of county workers or of the county, and we're able to secure SIJS findings in those orders. Or the individual themselves, a parent or aunt, uncle, brother, sister, that might be willing to step up in these sort of cases. And if we go to the next slide, it is one piece of a really, really complex puzzle or map, right? So
and I just want to note, sorry, one more note.
Go ahead.
Just because, so it's not only possible to make findings that would allow a child to become eligible for SIJS if they are placed in county custody. That's one situation, where it's determined that reunification with the parent against whom proceedings are started isn't viable. That's one situation where findings can be made. But if the child is returned to the parent or other relatives, as Kim mentioned, if there's a parent, for example, who's not party to the proceedings and maybe abandoned the child years previously, findings could still be made related to that parent and would allow the child to pursue SIJS. So just wanting to make it really clear, make the referral at the outset. The immigration attorney will make those factual findings with the child, and the request for findings can be made at any point in the CHIPS proceedings where the facts are in the record to make them. It doesn't have to be at the permanency stage. So just keeping back to you.
Yeah. So this state court process is one part of the puzzle, right? This little state court section is somewhere in that great big blob in the immigration court map, right? They are youth are starting with removal proceedings, court proceedings being initiated. They have what we call master calendar hearings, court hearings, where they have to show up, identify themselves to an immigration judge. Ideally, before the very end of that first blue bar, before they get to an individual or merits hearing, they are applying for SIJS. So going through that juvenile court proceeding, getting that petition filed, getting that order that is granting dependency and custody. And that is the link that we need as the Immigration Council to be able to file that I-360. Without that order, we really can't move forward with an I-360 application. At one point in time, we could file green cards concurrently. That is no longer the case. We are in a place where we have to wait for every single child for every single country. There is a delay for getting to that green card stage of proceedings. And ideally, all of this is happening before that individual or merits hearings. At your individual hearing, a child has to sort of establish and defend against any allegations that they are here unlawfully, that they have no right to remain in the United States. And I want to answer a question in the chat here. I'm going to click answer live. Asking about any accountability mechanisms that county workers have for ensuring that aged out youth have gotten proper documentation. That is definitely something that we see very frequently. This individual is saying that they're working with several undocumented youth that have either aged out or will age out soon, that are at 18 or might be already past 18, and it doesn't look like there was work done. Well, ideally in this situation, the child is still before that individual or merits hearing. And even if the child has turned 18, we still would have time to proceed with an over 18 at-risk juvenile order if we have the ability to do that. And we can still file that I-360 up to age 21. And that is the only requirement to be able to get that status. It doesn't matter for your green card. You can be over 21 for that. So yeah, we definitely would encourage that folks, even if youth are at 18 or over 18, that they make that referral, because there could still be options before any sort of removal order is placed in their case.
And even if there is a removal order against the youth, there are things that we could still do. We could try to get the case remanded back to the judge. So early referrals are best and can put the youth in the best position, but any referral is better than none. We want to emphasize early referrals, but also referrals at any point if you see it wasn't made previously.
Mm-hmm. And I want to talk a little bit about when you can identify these sort of referrals. I want to go into those state court definitions of abuse, abandonment, and neglect. So when we look at abuse, if you are talking to a youth, they're saying that they have experienced any sort of physical, mental injury, emotional injury from a parent, any threats against the child or against the person that is responsible for their care, if there are no parents around, is going to be someone that we could work with to get an I-360 filed for, because we would be able to rely on what happened to that youth in that situation and point to the state court definition of abuse. If we go to the next slide, we could also work with a youth where there has been allegations of neglect. So any omission of protecting the child or providing anything necessary for a child to survive, food, clothing, shelter, a failure to enroll the child in school, forcing them to work instead of going to school, not taking them to the doctor. Some youth have never gone to the doctor before. Those are cases where we might be able to make those allegations and get those findings in the state court order and move forward with a I-360 application later on. And then the last one is abandonment. So just disregard for the child's well-being, no contact with the child. Typically, we are needing at least no contact for between the child and guardian for at least 6 months, so that we can show that there is a statutory abandonment there for that youth. But yeah, being here without any sort of parent or guardian might be able to qualify in those situations. And that is one of the forms of relief that are eligible for youth. You could stay there, Allison. Another one is asylum. That is our bread and butter at the Advocates for Human Rights. We primarily work on asylum cases if any child is telling you that they have been harmed or fear return to their home country for whatever reason. I think it would be good for them them to talk to us if they are here in the United States, are sort of saying that they are scared of an individual or an organization, gangs, whatever it may be, even if they feel like they could be protected by the government. Often we can argue that there isn't, and this harm or threats of harm or possible future harm could be on really any basis. Asylum has 5 basic protected grounds. They are, if you go to the next slide, race, religion, nationality, political opinion, and what we call a particular social group. So it could be that someone was mistreated or something for their race or their ethnicity being part of a specific group. For a political opinion is much more broad in that sense. It could be not just left, right politics, but also feminist opinions about the status of LGBT individuals, someone's faith, if it is not being honored in home country, could all be reasons for threats or persecution and could be a basis for asylum. The last thing that is sort of the largest bucket of reasons why or how someone could apply for asylum is a particular social group. That is an incredibly complex area of law for practitioners of asylum. But I would definitely suggest that if a child is expressing any sort of fear related to any of those topics, even if the social group is just like young men from this country, there could be arguments that we can make on the immigration side of things to establish valid asylum claims. So referrals, please, for our agency. Another form of relief, and I'm just going to go through 2 more, is for victims of trafficking. Our agency works with survivors of labor and sex trafficking. So folks that are here in the United States on account of some form of trafficking of themselves. A lot of youth that are under 18 don't have to comply with any sort of investigation question. So it could be really scary to try to work with law enforcement to make sure that the person that is the trafficker is getting prosecuted. So there are definitely exceptions for folks that aren't able to do or aren't able to fully comply with those requests from law enforcement or investigative agencies to try to identify and stop that trafficking from happening. So if you have youth that qualify for that or that have been victims of crimes, we can go to U visas. We could also make referrals to agencies that do U visas. Not something that we personally focus on, but for any folks that have been victims of crimes, it does have to be a crime designated by the U.S. It has to have occurred in the U.S. It should be a violation of U.S. law. Are or can apply for to see if they're eligible for a U visa if they've been a victim of a crime. The crime does have to be substantial. There has to be significant physical or mental abuse if that person ended up in the hospital or in therapy. Those might be flags for you to say, oh, maybe this child or youth is eligible for this form of protection or for this form of relief. Yeah, and adoption, Allison, a whole other form of protection or being able to stay here.
Yeah, thanks, Kim. So we just want to flag for folks that youth who have been internationally adopted have particular needs and very often lack proper documentation of their naturalization or have not completed all steps for naturalization. We also see kids who had disruption in the adoption process, so where it wasn't legally finalized. or for adult adoptees who entered under prior law, and their parents didn't complete the process to obtain citizenship. There's many reasons adoptive parents typically were not given a ton of support. There's very little accountability to ensure that adoptive parents have done all the steps to ensure that adopted children, internationally adopted children, have their proper documentation. Adopted parents are often not very familiar with the immigration system. There's many other reasons that adoptees could lack proper documentation. We sometimes see adopted youth not finding out that they lack prior documentation until they're needing to travel abroad and seeking a passport, or in some cases until they're facing removal from the only country where they resided since they were a baby, the only country where they speak the language, the only country where they know how to work, where they have connections, where they have education. So it's incredibly important to ensure also for adopted youth that they have a naturalization document or a certificate of citizenship, and that they have correct social security cards. And there are resources I'm going to go through quickly because we have so much more content to cover. Just want to flag that there are good resources to refer to. The Adoptee Rights Law Citizenship Clinic, they provide free legal services and are based in Minnesota and are experts on serving international adoptees. MMLA, I am an attorney with MMLA. I'll just reiterate, we assist with certificates of citizenship and naturalization. ILCM, Immigrant Law Center of Minnesota, also assists with naturalization. So we'll talk about how to refer again in a moment. But the important thing is to make a referral to an immigration legal services provider. We work quite closely together and can refer to a different provider if we're not the best to serve the youth. And so we want to cover, there's lots of policy changes that we'll go through quickly because we do want to make sure to save time for the Know Your Rights and Safety Planning and Referral section. But we want to go through this to emphasize just how much more important it is to make quick and timely referrals. So Kim, I think the slide is you.
Sorry about that. Yes. So in court, we are seeing many youth facing proceedings alone. Nearly a quarter of kids appearing at Fort Snelling are about 10 years old or younger, 5% in that 0 to 3-year-old range. So definitely seeing a lot of vulnerable youth that are needing to present themselves before an immigration judge. Kids that have representation are obviously going to show up more to court. They're going to get reminders. They're going to be exhibiting less fear of showing up to court, ideally because they have some form of relief that they are working on or that is pending that they're working on with their attorney. But we are seeing across the board, all of our clients are saying that there is increased fear about going to court. They're asking about the options or the possibility of doing a WebEx or online based hearing. And for youth and families that is an option for, it sort of does depend on the immigration judge whether or not you are allowed to appear remotely. We do try to do that. In the adult context, we have been seeing many adults getting detained at immigration court. The process usually follows that the government says that there is no case or dismisses their immigration proceedings, which you might think is good. The judge no longer has the authority to immediately deport that individual, but then ICE is sort of waiting outside of courthouses to immediately detain individuals. And then they're moved to detention, which is a much quicker sort of a removal process for adults. Yeah, do you want to go to the next slide? So yeah, generally we're seeing faster removal proceedings, but Allison, go ahead.
Yeah, go for it. So as Kim said, we're seeing faster removal proceedings. Motions to dismiss is one of the issues. Motions to terminate. So I want to emphasize, these are for people who've done everything right. They filed their application for asylum. They showed up at all their court hearings. We're seeing this for lots of adults with dependent children. And so when adults get those motions to dismiss or terminate the proceedings, the children who are dependents on their case also get a removal order. So even if they're not detained at the time the parent is detained, they still have that removal order and are vulnerable to being removed at any time. So it's really important to be verifying early on, is this child in proceedings with their parent? When is their, and getting them connected with an immigration attorney who can figure out when their next hearing is and take the steps to sever their case. There's also many challenges for kids in proceedings. For example, there's fewer ways to pause their removal case. A lot of the ways we were able to ask the judge to wait while U.S. Citizenship and Immigration Services was making a decision on immigration benefits the youth had applied for. Judges are no longer allowing that. There's also less willingness to continue cases for agencies to make decisions on benefits, for kids to find immigration counsel. And then we're also seeing these motions to recalendar paused cases. The ICE lawyers filed motions to recalendar paused cases in hundreds, if not thousands of cases before our local immigration court. So folks have been waiting maybe for years, maybe just for a year, for their immigration benefits case to be decided, now have to proceed before the court. And then we're seeing more removal in absentia. We're also seeing a lot of challenges in obtaining benefits. So faster deportation and slower access to benefits. One is that there was a significant reduction in immigration court staffing and also staffing of benefits agencies at the same time that there was a massive increase in the summer in the HR 1 bill in staffing of ICE. So more people are placed in proceedings and fewer staff are able to process their applications for benefits and hear their cases before the court. Also, USCIS has been very focused on perceived fraud in cases and is spending a lot of their agency time on that issue, re-adjudicating cases that were previously decided to see if there was fraud, and then a benefits adjudication pause. So those things that we talked about before, applications for asylum, applications for permanent residence, for many countries are completely paused. Asylum application adjudication by USCIS is completely paused. And then again, there's the end of many forms of temporary status. And the federal government's messaging encouraging self-deportation is also creating a lot of confusion. Self-deportation is not a legal process. There have been flyers posted at every immigration court, passed out with every immigration notice received from the court, and sent to individuals through many other ways, encouraging them to self-deport, which just means to leave the country. But many people who are in removal proceedings would be then abandoning forms of relief, would be putting themselves in a position to get removal orders, would be preventing their ability to return to the US in the future. And so we've been trying to do a lot of messaging to clarify to folks that self-deportation isn't a legal avenue and would create problems for many people. Our different agencies, for example, MMLA has a video on self-deportation versus voluntary departure, for example, is a legal process that may be an option for some folks. And then, of course, as you've seen, there's increased enforcement of various types, not just by ICE, but we're also seeing enforcement against youth, enforcement against people who are seeking naturalization with fee waivers. The USCIS officers, which has been a benefits agency throughout its existence, have now been deputized to engage in enforcement. And back to you, Kim, for additional legal hurdles.
Yeah, I'm just going to go through this really quickly. We're running out of time here. So someone asked about our current capacity to accept legal referrals. In addition to all of this, legal agencies have had issues with funding for children's immigration legal services that has been threatened or threatened to be cut. So our capacity is often in flux, but definitely make those referrals. Sometimes they can take some time. Sometimes we have a wait list for folks to be able to sort of finish intake and get on through. But a lot of our agencies do work with pro bono attorneys, and with the status of the world, I am hoping that there is an increase in pro bono interest in assisting youth, especially through these processes. I'm going to go ahead and skip on the rest so we can move on to referrals. In the little QR code, you can go directly to our intake line. Our intake is Tuesdays and Thursdays. We have 2-hour sections, so it is a limited time that we are able to sort of bring people in for all of that.
So MMLA, I work with MMLA, and we take basically everything that Advocates doesn't. We do focus on youth cases as a large portion of our caseload and do SIJS, and we only do asylum for youth. So, but we also work on U visas, T visas, VAWA applications, adjustment, naturalization, and removal defense. So I want to emphasize, when in doubt, refer to, except for adult asylum, send those to Advocates. If we can't take the case, we'll refer to another provider that can assist. I've included provider emails here so that folks can most efficiently refer their clients. People can also, of course, contact our general intake line, and we'll put that in the list of links that we're going to send out after the presentation. But if providers email over information about the case and can explain to us that the child is in a CHIPS or juvenile delinquency proceeding, that really can help us identify how we should prioritize them in the wait list, who can take on the case. So please include that information so that we can best serve youth. And then just to quickly flag this, La Help MN also has a list of other providers that may assist. For example, Immigrant Law Center of Minnesota assists youth who are SIJS eligible and does removal defense. So you can find contact information for other providers by using La Help MN search features. And then for youth who are going to live with a caregiver outside of Minnesota, we've posted Immigrant Advocates Network's legal directory, which allows you to click on the state that the youth is going to go reside in and find the providers for that state. So we would encourage you, if the child's not going to immediately move, to still reach out to us so we can assist with reviewing potential orders and assist with pursuing findings needed for SIJS, but also encourage you to assist the youth in connecting with counsel in the state they're going to go to. They need to change their venue of their case. They need to do lots of things that they're going to need immigration counsel for. And so just a really brief overview of all the steps that caseworkers should have a checklist of to ensure that you're protecting kids' rights. And we're going to share resources, links for help with all of these different steps. As Kim said, limited capacity is an issue, although we're always trying to find ways to increase capacity. But there are brief services clinics. We'll provide you a page for the Regional Hub for New Americans, which lists both Metro and Greater Minnesota brief services clinics where folks can go for at least brief advice. We still encourage you to, throughout the pendency, to refer quickly at the outset. Throughout the pendency, keep trying to get the child full representation by an immigration attorney. But in the meantime, you can assist the child in accessing these brief services clinics for advice. And important steps at the outset: ensure the non-citizen youth has access to their immigration paperwork and proof of status. So if they don't have both a U.S. birth certificate or certificate of citizenship or naturalization and a social security card, important to refer to immigration counsel to assist. Also important to advocate for the child to get copies of their immigration paperwork and work with the stakeholders in the CHIPS case to ensure that the parents are providing that paperwork to the youth. And if not, that if there are problems in parents doing so or they don't have the paperwork, at the brief services clinics, youth can get help doing a request for a copy of their file from immigration authorities. We also want you to ensure that non-citizen youth and their foster families or other caregivers have training on their rights and encounters with ICE. We'll share videos. We'd encourage you to have youth watch regularly so that they have fresh in their mind what their rights are in different situations. For example, in their home, on the street, in their school. Youth have different rights and should be ready to exercise them, and to plan for what identity documents are going to best protect them to carry. Also, youth and their guardians need to have an emergency plan in place and appropriate parties should have copies. So who are their emergency contacts? What's their caseworker's contact information? What's their attorney's number? So if there is an emergency, the proper people can be immediately contacted. That should have copies of their immigration paperwork attached to it, copies of any prescriptions the youth takes. And I wanted to go back to number 2 and just flag that youth with any mental health barriers or younger youth are going to need particular assistance in ensuring that they're able to exercise their rights in encounters with ICE. We often see that ICE is arresting people who have serious mental health issues and aren't able to explain their status or then advocate for themselves once they're detained. And so going to number 4, really important to ensure that non-citizen youth and their guardians understand how to protect their rights if they are detained. Youth who are under 18 would be detained in an ORR shelter. Youth who are over 18 would be detained in an ICE facility. And so we'll share a link for the ICE detainee locator so that you can assist youth and so you can assist families in figuring out where the youth is detained if they're over 18. Again, it's very important to connect youth with at least a brief consult and then to continue to connect with counsel throughout the pendency of the CHIPS case. And please take a look. We're going to share various Know Your Rights resources with you. Please take a look and make sure that youth have access to these and their guardians. They particularly need your support in making these plans as they may not be as familiar as immigrant community members with these resources. So flagging more resources for you to take a look at following this presentation. The DCYF agency has a bulletin on SIJS, which is a good basic overview. The Center for Immigration and Child Welfare Initiative has lots of great resources for social workers specifically on recent changes in immigration policy and how they impact the folks who serve. The Regional Hub for New Americans has fact sheets, lists of clinics, provider training dates, so you can keep learning. Know Your Rights resources and guides on navigating the immigration court systems. You can see if children have an upcoming hearing. The SIJS Backlog Project has resources for youth who are waiting to be able to adjust on navigating that. Twin Cities Immigration Forum is a regular presentation, a regular forum where providers from the different immigration services nonprofits appear and talk about updates on immigration issues. And this is a free event. You can attend whether or not you live in Minneapolis. It's put on by Minneapolis and St. Paul, but you can sign up. I've provided the link to the city of Minneapolis's calendar where you can sign up regardless of where you live throughout the state. And then there's a few other things that are linked here. We encourage you to attend the Center for Advanced Studies in Child Welfare Spring Conference for more. And do we have time for questions? You know, we tried to get through our last few resources quickly.
I think maybe just 2 or 3 minutes for questions and then we'll get the rest shared out. So yeah, let's just take a couple minutes if we can.
Okay, great. And we just want to leave you with make referrals early and keep trying to get kids connected with counsel. It's more important than it's ever been. And make sure you're providing Know Your Rights and safety planning resources, which is also more important than it's ever been. You are going to be that youth's best ally in being safe and securing permanency by helping them get immigration status. So we're so grateful to talk to you. What questions do people have? Sorry, I can't see them.